Life can be complicated yet simple. It is up to the person's attitude and mental aptitude to not get trapped in the needless complexities. They can break it down into simple, understandable things. But when it comes to making things complex, there is no limit to overthinking and intentionally browbeating the definition of something just to showcase one's oozing intellectualism. The ongoing case in the Supreme Court over granting legal sanction for same-sex marriage has sparked a new debate. It has thrown open the debate to challenge the established notions of sex, gender, identity, biological male and female, and gender fluidity. So here are the key developments from day 1 and 2 that took place in the Apex Court in this matter. Namaste and welcome to TFI Post. I'm your host Paulish Gupta. Let's begin. A 5-judge Supreme Court bench is hearing a bunch of pleas to legalize same-sex marriage and its further implications. The bench is headed by CJI D.Y. Chandrachud. The bench also includes Justices S.K. Kaul, Ravindra Bhatt, Hima Kohli, and P.S. Narasimhan. Around 20 petitions have been filed before the Supreme Court to seek recognition of same-sex marriage as available for heterosexual partners. For this reason, the petitioners have requested that the Apex Court amend provisions of the Special Marriage Act of 1954. They want to change the wording so that marriage is between spouses instead of man and woman. Senior advocate Mukul Rohatgi appeared for the petitioners. He argued that the LGBTQ community should have the same right to a dignified life and institution of marriage and family that is available to heterosexual partners. The petitioners have claimed before the court that LGBTQ+ citizens constitute around 7 to 8% of total population. The petitioners argued that LGBTQIA+ persons were not entitled to the legal protections provided by 15 laws that guarantee the right to wages, gratuities, adoption, surrogacy, among others. The Union government is being represented by Solicitor General Tushar Mehta. Clearly displaying the centre's opposition to these petitions, he challenged the maintainability of these petitions. Mr. Mehta stated that the Supreme Court first needs to address whether the judiciary is right forum for this case. He strongly argued that the Parliament was the only constitutionally permissible forum to decide on the creation of a new social relationship. Further, he asserted that we are still questioning whether it's for the courts to decide on their own. The Union government termed the idea of same-sex marriage merely an urban elitist view. As per the Union government, the creation of a new social institution like same-sex marriage cannot be claimed as a matter of right. According to them, it is only the Parliament and not the court that have the right to decide on same-sex marriages. As such, marriage is a threat to the holy union of marriage between a biological male and female in India. Responding to Mr. Mehta's argument, the CJI remarked that the court cannot be told how to make a decision and that it wants to hear the petitioner's side. However, the Supreme Court bench categorically stated that the focus of the case is limited to the Special Marriage Act and that it would not touch personal marriage laws. Responding to the CJI, Mr. Mehta replied by saying, then let the government decide how far it will like to participate in these proceedings. Further, Mr. Mehta pointed out that at present the idea of marriage was limited to a union between a biological male and a biological female. In the flow of the argument, CJI Chandrachud questioned the current understanding of sex and gender. CJI Chandrachud said, and I quote, "The assumption that the very notion of a biological man or woman is absolute is not true. There is no absolute concept of a man or a woman. It's not a question of what your genitals are. It's far more complex than that." Unquote. Agitated by the remarks of CJI D.Y. Chandrachud, one of the petitioners, Abhijit Iyer Mitra, shared a Twitter thread to condemn the remarks. The remarks questioning the concept of biological male and female have not gone down well among a large section of the society. They have argued that while gender fluidity should be discussed and deliberated, unscientific remarks will only hurt the cause of the petitioners, derail the case, and throw it on the wrong track. As per their limited and humble submissions, a large section have argued that biological male and female on the basis of genitals cannot be questioned in such a loose and capricious manner. The Supreme Court bench has been discussing the ambit of gender and whether it expanded beyond the biological sex of a person. On day 2 of the hearing, the centre filed an affidavit before the court asserting that states and union territories should also be made parties to this case. The affidavit claims that the matter falls within the legislative domain and thus views of all states and UTs on the same are necessary. The affidavit states that it is clear that the rights of the states, especially the rights to legislate on the subject, will be affected by any decision. The strong arguments raised by the center, particularly the concerns that the views of state government should be taken into consideration, will ease things up, especially for those who are jumping the gun and seeking favorable outcomes without having proper discussion on this matter purely on the basis of their political agenda. The verdict in this case will have far-reaching consequences, some of which are still not yet fully comprehended by a large section of society. Granting legal sanctions to same-sex marriage accompanies the debate on its implications like adoption, abortion, succession, surrogacy, criminal laws on physical assaults, among others. Now let me leave you with few permutations and combinations that should be analyzed before framing laws regarding this. Will the law allow lesbians to marry at the age of 18 and gay couples at 21? But they refuse to accept the definitions of biological male and female? In that case, can the gender-neutral terminology like person be replaced to allow marriage for same-sex couples at 18, or will it be 21 then?